I want to talk about this decision by the Colorado Supreme Court and Donald Trump because obviously the Democrats are desperately trying to make sure that no pro-Second Amendment candidate wins the White House or any position. And because there's a lot of misinformation out there about this Trump issue in the Colorado Supreme Court, I want to break it down for you because it's my goal for you to be the smartest person in the room when it comes to the Constitution, in particular the Second Amendment. But there's some lessons to be had from this decision by the Colorado Supreme Court that I think will be helpful for you to understand in debating issues such as the Second Amendment going forward. And because I'm one of the few people I think can explain this in a way that you will understand it and will actually make sense and will be correct, I want to get it out to you so you can use it as you see fit. Okay? Stay tuned. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and I'm proud to say I was nominated for 2 Gundy Awards for 2024, Top Voices of the Second Amendment, as well as one of the top male influencers. I'm proud and honored by those nominations. All right, folks, so Colorado Supreme Court has just decided in a long opinion, 4-3 vote, 4-3, that Donald Trump should not appear on the ballot in Colorado for the Republican nomination to be president because he engaged in insurrection on January 6th and so on. So I just want to get into some of the geeky details about this because I think talking about this constitutional issue will help us understand other issues involving the Constitution, such as the Second Amendment. So to begin with, I just want to say first and foremost, as a practical matter, this decision by the Colorado Supreme Court, in my opinion, in the short run at least, is a publicity stunt. The reason why I say this is because they wrote this very long opinion attacking Donald Trump, the typical Donald Trump is bad stuff, and they basically, of course, defer heavily on the trial court judge in Colorado that said he engaged in insurrection and so on. Nevertheless, despite all of this, they then go on to say that he is not eligible for run for the White House under Section 3 of the 14th Amendment. Now, the Section 3 of the 14th Amendment provides as follows, that no person shall be a senator or representative in Congress or an elector of the president or vice president or hold any office, civil or military, and that's key, hold any office, civil or militarily, under the United States or under any state who having previously taken an oath as a member of Congress or as an officer of the United States or as a member of any state legislature or as an executive or judicial officer to any state or of any state to support the Constitution of the United States shall have engaged, and this is the key language, shall have engaged in insurrection or rebellion against the same or given aid or comfort to the enemies thereof. Now, before we even get into some of the more details, let's just look at this as a textual matter because as Second Amendment proponents, we always like to look very carefully at the text of the Second Amendment. The right of the people to keep and bear arms shall not be infringed. That language, of course, presupposes the existence of a pre-existing right? The right of the people to keep and bear arms shall not be infringed. That presupposes, as the Supreme Court has said in Heller and Bruin and beyond, a pre-existing right. So let us take a look again at this language from Section 3 of the 14th Amendment. Let's see if we see some similarities to that. Specifically, let's look at the language as follows. Shall have engaged in insurrection or rebellion against the same. Shall have engaged in insurrection or rebellion against the same. See that language? Well, there's a very strong argument among many constitutional scholars. I'll put some links to it down below. You can check out people that spend a lot more time on this issue than I have. There's a very strong argument that that language in the 14th Amendment specifically applies to events that occurred before the enactment of the 14th Amendment in 1868. Because it's, of course, presupposing that something that occurred before 1868 constituted an insurrection or rebellion. And what might that be? Well, we know what the answer is. It's called the Civil War. So just textually, there's a very strong argument that this was applicable only to those that engaged in the Civil War in the 19th century and is not forward-looking in that sense, because if you look at the language of shall have engaged in insurrection or rebellion against the same, i.e. a date before 1868. So just textually, it's not even clear this could apply to an attempt or an actual insurrection in 2020 or beyond. But let's go beyond that. Let's see what is the practical effect of this decision, and then we'll go back to some other points about the substance of the law. The next thing to keep in mind is, what did this court opinion say? So, of course, it attacks Donald Trump and says all sorts of things, but the critical thing here, remember, we've talked about this before. You have the decision, the substantive law on the substantive decision. Here, the substantive decision is that President Trump engaged in insurrection. That's the decision. That's the finding. But then here's the key. Remember, we've talked about this quite a bit. There's the decision and there's the remedy. What was the remedy that this 4-3 decision by the Colorado Supreme Court issued? Well, it turns out it's a very favorable remedy for President Trump. Here's what it says. To maintain the status quo pending any review by the U.S. Supreme Court, we stay, which means to freeze, we stay our ruling until January 4th, 2024, the day before the Secretary's deadline to certify the content of the presidential primary ballot. And here's the key language, folks. If review is sought in the United States Supreme Court before the stay expires on January 4th, 2024, then the stay shall remain in place, and the Secretary shall continue or will continue to be required to include President Trump's name on the 2024 presidential primary ballot until the receipt of any order or mandate from the Supreme Court. You see that? They gave the Democrats what the Democrats want, and then they took it all away. Because if you look at that language here in the remedy says that this decision, this says Trump engaged in insurrection is ineligible to run for the White House under the 14th Amendment. That decision is stayed at least until the day before the primary ballot, before the primary election, January. But beyond that, it says that if there is a review, which is going to be, because Donald Trump is going to certainly seek review of this decision by the U.S. Supreme Court, if the review is sought, the stay continues. So again, because the Supreme Court of Colorado says if review is sought in the Supreme Court before the stay expires on January 4th, which means President Trump seeks a stay between now and January 4th, which he will, then the stay is going to continue in place, which means it's not going to go into effect. So as a practical matter, in Colorado, this is unlikely to matter. Now, that, of course, goes beyond the normal political points, that one could say that it doesn't really matter what happens in Colorado because Donald Trump's likely going to lose that state because it's a blue state. On the other hand, you could come back politically and say the downside to President Trump not being on, let's say, the general election ballot, if he gets the nomination, would be it would hurt any pro-Trump candidates running down ballot. So there's a practical effect in that sense, although I think, again, it's unlikely Colorado will vote for President Trump in a general election. Beyond that, we also have to say the following. I think the biggest concern here, and remember how we've talked about how there are these ripple effects. You have a good Supreme Court decision or a good lower court decision in favor of the Second Amendment, let's say, and other courts subsequent to that can then use that decision. I like to call it building bricks. We have a good decision in Vermont, a good decision in Florida, a good Second Amendment decision in Colorado. Each of these decisions are precedents, legal precedents, or bricks that can then be used to build a wall around our Second Amendment rights. Well, of course, the Democrats can use that against Donald Trump in the following way. We know right now, by my quick back-of-the-napkin math, there's other pending cases that say that President Trump cannot appear on the ballots in places like New York, Nevada, Alaska, New Mexico, Wisconsin, Vermont, Virginia, South Carolina, West Virginia, New Jersey, Oregon, Wyoming, and New Mexico, and so on and so on. So those states courts could potentially use the precedent of the Colorado decision as a basis to keep him off the ballot in those other cases. And for those super illegal geeks out there, there is a doctrine known as collateral estoppel that says that if you've engaged in a litigation and had the opportunity to be heard on a case, and factually you are found to have done something wrong as a matter of fact in one jurisdiction, collateral estoppel can sometimes be used against you in subsequent jurisdictions where they don't have to relitigate the case. So one wonders whether or not the Democrats will use an argument that the Trump campaign is collaterally estopped under these other jurisdictions by virtue of the findings of fact engaged in or found by the Colorado District Court or the Colorado Trial Court. I think that's unlikely to apply here, but that is something to keep in mind for you super geeks out there, whether or not the doctrine of collateral estoppel could apply against Donald Trump in this context. So a couple other things why I think it's pretty clear President Trump is going to win this case on the merits. Specifically, if you look at the language of Section 3, it talks about if someone who held an office, you have to be an office holder. And it's pretty clear if you look at, and there's other scholars, including Professor Josh Blackman and Professor Seth Barrett Tillman, who wrote an article, I'll put a link to it down below, that have argued very persuasively, in my opinion, that Donald Trump is not an officer of the United States, under the meaning of this Section 3 or under Section 3's text. These scholars looked at the original meaning of the phrase and then contrasted it with that phrase as used in other constitutional contexts, other constitutional provisions that discuss officers of the United States, and And in those other provisions, it's pretty clear they're dealing with oath holders and commissions clauses and things like this that would not be necessarily applicable to the President of the United States. So you can't really, so officers of the United States cannot mean one thing under the 14th Amendment and something else under the rest of the Constitution. That would be inconsistent. Beyond that, Chief Justice John Roberts, in a case of Free Enterprise Fund versus Peekaboo, PCAUB. Peekaboo is what I think it's been called. Free Enterprise Fund versus Peekaboo says that in the United States, officers of the United States are appointed officials. They're not elected. Again, that is a Supreme Court decision from about 15 years ago, I think. Free Enterprise Fund versus Peekaboo. John Roberts wrote specifically that officers of the United States are appointed. They're not elected, which means, of course, that the U.S. Supreme Court would probably find that Donald Trump, as an elected official, would not be an appointed official, and thus would not be an officer. Because he's not an officer, you cannot keep him from being the President of the United States, because, again, you can't be an officer, perhaps, but that doesn't prevent you from being the President, among other things. And, of course, relatedly, he was not an officer as President. He was the President, which is separate from an officer of the United States. And the last point worth noting, there's a case called the Griffin's case from 1869. The Griffin's case is a Supreme Court case. I think the Supreme Court justice, by my note here, is Justice Chase. And Justice Chase wrote in 1869 in the Griffin's case that specifically the only way you can effectuate our Section 3 of the 14th Amendment is by an act of Congress. I mean, it's up to Congress to make a determination as to whether or not you've engaged in insurrection and whether or not you're ineligible or eligible to run as president or as an officer or whatnot under Section 3 of Article 4 of the 14th Amendment. And because Congress itself has not found that Donald Trump is engaged in insurrection, thus cannot run under the 14th Amendment, it doesn't matter what the courts say, because this is a decision according to the Griffin's case from 1869 by the U.S. Supreme Court, a decision by Judge Chase, that indeed the decision as to whether or not you engage in insurrection and cannot run under the 14th Amendment is a decision for Congress and not the courts. So it really doesn't matter what the courts think, including, among others, the Colorado Supreme Court. So for these reasons, I think substantively this is an argument against Donald Trump that is going to go nowhere in the courts outside of kind of these partisan courts. And I think people who know, the Colorado Supreme Court, I think, is probably fairly hyper-partisan, and they're 4-3 really. And still, they weren't even unanimous. It was still 4-3. So with that said, I just want to bring you up to speed. A few thoughts. I know this is not specific to the Second Amendment, but these are constitutional issues. And again, the way you interpret and apply and consider the Constitution in some other context is equally applicable to the Second Amendment, so it's good to know the stuff here. All right, folks, hope you learned a little bit something here today. We'll talk more about the Second Amendment in the future. Don't forget to follow us on X at 4Boxes Diner, and we'll see you again soon here at the 4Boxes Diner.
Orders up. Table 2A.